Hi, gang. I'm Gordon Firemark, the podcast lawyer. Welcome to the Podcast Lawyer Live. It's Thursday. It's 4 p.m. Pacific time, and that's why I'm here to go live. Forgive the echoey room I'm in. I'm experimenting with some natural reverb. That's what it is. No, I am in the midst of chaos here. I have had to take everything out of this office, my home office / studio, because we had a flood, a pipe burst, and anyway, so that's the explanation for the highly reverberative room, and I'm hoping that you're not getting too much of that in the actual live stream feed. But in any event, I wanted to say hello and talk about a couple of topics today. We've got what do we have on the horizon? Let me see. We've got the usual stuff about music going on. I'm seeing in all the Facebook groups over and over again. Hey, do I need to get a license or whatever? And one podcaster actually posted that she had recently moved their show to a different producing team. So they were using a third-party producer, and that producer had built an intro for them around some very famous music from a very famous artist, and had not gotten any kind of licenses. I'm going to have to adjust what's happening. Okay, so had not gotten any licenses for the music they were using because it was pop music from a particular artist, and when they presented it and asked, no licenses. We don't need it. It's only a few seconds. That's not the way it works. Anyway, so that look, everybody in the Facebook group said, no, of course you need, of course you need music licenses for that. So I don't need to belabor that point, other than just to express really quickly. I'm just going to say it. If you create a work, anybody who creates a work, whether it's a podcast, whether it's a song, a painting, a film, a photograph, whatever, if it's got any modicum of originality in it, it is copyrighted material from the moment it's created. And so the owner, the author, creator of that work is its owner and has the exclusive right to say yes or no to someone else using it, to charge money for someone else using it, to allow for it to be included in other works and so on. So when you incorporate a piece of music into a podcast, you are doing one of those things. You can't do that without the permission of the owners of the copyrights. And so there are actually a couple of copyrights you have to think about. The first one is the musical composition, right? The work of the songwriters or the composers. And they generally sign up a deal with a music publishing company to handle administering that and collecting the money for uses of the musical composition. But there's also the sound recording that embodies that song, and that's the recording artist makes that sound recording, usually at the behest of a record company, and that record company generally owns the copyright to the recording. So if you want to use a piece of music for an opening or an intro or whatever in your podcast, you have to get permission from both of those parties, from the music publishing company that controls the composition and the record company that controls the recording. Now, of course, if you make your own new version of the recording, you wouldn't need to deal with the record company, but you'd be dealing with the music publishing company in yet another way. So it adds up to a fairly complicated scenario. Now, the other thing that you often hear is, well, it's just a little bit. It's just a few seconds of music. Why would I need to get a license? And isn't it fair use? Well, you might be in fair use territory if you're using a very little bit for criticism and commentary and those kind of things. But when it's the opening titles sequence for your show, the opener, that's something very different. And you need to, think about it. That's not a fair use kind of a thing. So even though you're only using a few seconds, you're going to need that permission. So most of the folks in the Facebook group responding to that particular question had it right. So you all are getting the message. I guess I'm having the impact I aim for because more folks seem to understand this concept. But we have to remain vigilant about this. So I want to bring it up every time I do it. Hey, do you guys notice the colored lights changing in the background? I'm just having a little fun with that. I've got some color changing effect on on my LifeX lights, and I think it's kind of fun. Anyway, I'm redecorating the studio once the contractors have finished putting the building back together around me. Hopefully that'll be about another week, and we'll be done. And then I'm going to be doing some acoustic treatment. I'm going to be doing some design work, so I'll have some. Anyway, I'm looking forward to it, as you can tell. All right, next up, let's talk about the next topic. This is a question I saw in the podcast movement group. It was brought to my attention by, who was it that brought it to my attention? Tom V over in the podcast movement group said, brought this to my attention. The person who asked the question said, "Hi all. For podcast names, is removing the word the from a title considered a different name? For example, I have a podcast called The Way of Healing Podcast. If someone started a Way of Healing podcast, is there anything wrong with that?" And I'm going to say, yes, there's something wrong with that. Here's the thing. Branding like that is all about eliminating confusion, creating distinctiveness, right? So if you have The Way of Healing and they have Way of Healing, there's no way to distinguish between those two. And so they are confusingly similar. That's the test that we use when we talk about trademark infringement. Now, this may or may not be a case of trademark infringement if there's no registered trademark, but even then, there may be other claims. So let me just tell you, some of the folks in the group said, no, this is no problem. There are a lot of podcasts out there with similar, even identical names. And that is true. There are a lot of podcasts out there with similar and even identical names. And generally speaking, in order for something to be entitled to that trademark kind of protection, it needs to be a distinctive indicator of source or origin. Now, Way of Healing might or might not be distinct. I think it is a pretty distinctive term. It isn't generic. It isn't descriptive. You know, generic might be if you called it the health podcast, right? Or the healing podcast, maybe even. But Way of Healing starts to take it into a little bit more of a brand, and so it becomes distinctive. It's also not descriptive of things. Now, my own podcast title is an example of a highly descriptive brand or trademark. Or title. It is my own podcast name, Entertainment Law Update. Tells you exactly what you're getting. But there's a principle in trademark law that you can acquire the necessary distinctiveness over the course of time by using it long enough. It develops that secondary meaning in the mind of the consuming public, and that gives it the distinctiveness that's needed. And so it's entitled to some trademark protection. Hey, Ted, nice to see you. Good to see you here today. Thanks for joining. And if, by the way, anybody else who's watching, feel free to drop a note in the comments and say hello. I'd love to chat. And yeah. So anyway, people in the comments for that question said things like, "Oh, only if they're trademarked. Otherwise, it's fair game." Not true. And I'm going to get into the why in that in a minute. That commenter, though, went on to say, having said that it's difficult to differentiate if it's a high audience podcast. You risk being a Me Too copycat. And that's true, right? And essentially what one is doing is riding on the coattails of the other, right? If I build a powerful audience, the big audience for my powerful show, and then you come along and make your show with a title that the audience is confused by, that they think they're going to listen to me, you attract them by using that confusion to your advantage. The other side of the coin is that you can tarnish the reputation of my podcast by putting out a crappy one. So, you're passing off yours as something that belongs to me, or mine as something that belongs to you, and that's not cool under trademark law. But what if you don't have a registered trademark? Here's the thing about that. I'm gonna show you a section from the Lanham Act. The Lanham Act is the United States trademark law, passed in 1946. And there are also state trademark laws, by the way, but the Lanham Act is the controlling law for trademarks in the United States. And if you cross interstate boundaries, if you get into interstate commerce, you're governed by this Lanham Act. And a podcast, because really isn't bound by geography, and it uses the internet and the wires. It crosses state lines, unless you can prove all your listeners are in one place, but that's pretty unusual. Anyway, here's that code section. It's section 43A of the Act itself, but it's codified in the U.S. Code at Title 15, Section 1125, and it's about false designations of origins. It is, bear with me for a second. Okay, it says any person who, on connection or in connection with any goods or services or container or so on, uses in commerce any word, term, name, symbol, or device, or any combination, or any false designation of origin, false or misleading description of fact, or false or misleading representation of fact, like, hey, this show is coming from those people, or those people are related to my show in some way, that is likely to cause confusion, mistake, or to deceive as to affiliation, connection, or association, or as to the origin, sponsorship, or approval of his or her goods, services, or activities by another person, shall, down there at the bottom, shall be liable in a civil action by any person who believes he or she is likely to be damaged by that act. So there it is. If you use a term, name, symbol, or device that is misleading or false, that leads others to be confused or make a mistake as to the source or origin of the goods, that is likely to cause confusion in that regard, you are responsible for infringement. This is called the unfair competition component, and it does not require that the trademark have been registered. So it's a common misconception that if you haven't registered, you've got no recourse. But in fact, this Lanham Act, Section 43A, does in fact provide that you are protected to a certain degree. Now, a registered trademark gives you extra ammunition, extra help in proving your case. So that's the thing. So other people in that comment thread also said, it depends if you're wanting to start something similar or someone else's. If you're thinking of doing it, just don't. You'll just struggle to differentiate from them. I'd try to find yourself a different name so you don't live under their shadow. I think that's really good advice, even if you leave out the legal aspects. Even if you trademark and the other podcaster was using it first, it only protects you moving forward, not retroactively. If you have to use an existing name to title your podcast, hi Jay, if you have to use an existing name to title your podcast, you're already headed in the wrong direction. And, the fact is, putting the word "the" in front of an otherwise existing brand, or deleting the word "the," has no material impact on whether or not there's likelihood of confusion for the purposes of these laws, right? So obviously, if they have registered, then they can slap you pretty hard, pretty fast. But even if they haven't registered, if they were there first and there's a likelihood of confusion having been created as a result, there could be civil action and liability. So my advice is pick a distinctive name for your show. And how do you do that? Well, do some research, do some thinking about it. Do a trademark search. Please, I'm at least once a week, I hear from somebody who has gotten a cease and desist letter or needs to send a cease and desist letter because someone else has titled their podcast something that's similar to someone else's podcast, right? Just do some searching. It's not enough just to do a Google search and then assume, well, I don't see anything in the podcast directories. Although even that's better. I mean, people don't even search in iTunes or Apple Podcasts before they name their podcast. And that's why we have so many coming up. Yeah, uspto.gov is the trademark registration, where you can find a search for the trademark registration database for the United States. Jay has very kindly put that into the comments. There you go, Jay. Oh, that's too small. Let me adjust that right now. Let's see if I can make that. Whoops, there it is. Let's see if I can make that nice and big. All right. Whoops, well, it went away. Anyway, uspto.gov, that is not the end of the inquiry. There are more comprehensive searches that you can do to identify common law uses, businesses out there using similar titles, things like podcasts, which may not be registered as trademarks, but they are still problems. They're still cause for confusion. And And you want to make sure you do a search. So if you're serious about choosing a brand for your show, it might behoove you to do a real trademark availability search, brand availability search. Spend a few $100s, avoid a few $1,000s in legal fees later on. I think it's a worthwhile investment. And reach out to me. I can help you do it if you need to. But you can also just do that yourself. There's plenty of services out there that do trademark availability searches. So there's that. Next question that came up for me was, well, I've got to find it here. Let's see. Oh, about pay-to-play podcasting. Now, this came up in a group, excuse me for a second, where somebody posted, hey, if a guest is paying someone to get them booked on my show, shouldn't I get a piece of the money they're paying? Now, this implicates a couple of things in my view. First of all, we all know there are podcast placements or booking services where someone who has a message to get out and wants to get on podcasts, they can hire an agent essentially to represent them and pitch them to various podcast hosting hosts and things. And that's a perfectly legitimate strategy. Those agents are being paid for a service of doing the legwork, doing the pitching. You could hire an assistant and make them an employee and do the same thing. So if you pay that agency $100 a month or something like that to get you on 5 podcasts every month, then you're paying them $20 a podcast, right? Should the podcast host share in that $20? I mean, arguably, I can see the point, right? However, if you're a podcast host, and I think most folks will agree with me, this thread went on for much longer than it needed to. Went looking for it today and couldn't find it, but it was a few days ago. Most folks seem to agree. No, if your show, you benefit by getting the guest, and the guest benefits by having had them, find the job for them, find the opening, and make the pitch and manage the transaction and so on. But if you were to collect money from the guest or through them for the guest's appearance, then I think that raises this question about pay-to-play podcasting. Now, there are some podcasts out there where the guests pay a fee for the exposure to get on the show. And I don't know which shows do and which shows don't. I know there's a handful that do, some very prominent shows. And, for some people, they may feel that's worthwhile. But what I will tell you is that the Federal Trade Commission has rules that require full disclosure by anybody who receives compensation in exchange for putting a message out to the public. It's sort of like, we talk about it in the case of affiliate ads, for example. If you're an affiliate and you open a product and you talk about it and you would say, hey, go get your copy of this at Amazon or wherever, and you collect an affiliate commission for every sale that's made, you have a duty of disclosure. You're required to let your audience understand that that's what's going on. Well, I submit to you that a paid appearance on a show is the same thing. You are essentially endorsing the guest by having them on your show. And if you are getting paid for that endorsement, your audience has a right to know. After all, they are putting their faith in you as the podcaster and trusting that you are presenting things to them in a way that is useful and fair and all of that. And so they have a right to know if you've been paid to endorse this particular guest. You may not agree with this guest at all, and for all they know, all your audience knows you love this guy or this woman or this book that they're promoting or whatever it is. But if they've paid you, maybe you're doing it for the money, and so they have a right to know and understand that, and that requires a clear and conspicuous disclosure of the fact that they've paid you to be on the show. So pay-to-pay podcasting, is that really legit? I think, okay, fine. If you're going to do it, make sure you get those disclosures. But back to the guest paying the agency to get them booked on the show. What do you do in that situation? First of all, it's probably not that much money. And if it is, it's just sort of de minimis. But do you need, so if you're collecting $20 from a guest to come on your show for 15 minutes or whatever, and you have to say that, I don't know if that's worth it, right? So should you get paid just because the agent's getting paid? I say no, not really. Although I understand the thinking. No, they're doing a service for their client, and by extension, it's a service for you. And I think we ought to be appreciative and grateful about that. So I'm gonna have to get with one of my friends and just have a conversation about this particular topic. Maybe we'll do that as an interview for a future episode of the podcast Lawyer Live. Anyway, I'm good to take some questions. I don't have much more to talk about than that, other than the FTC rules, the trademark stuff around titles. Choose your titles carefully, please. And please, if you're going to put music in your podcast, get the licenses you need. It's not as easy as it seems. Other than that, I think I don't have any other hot news in the in the podcast space. And I don't know. Jay, what's new with you? Ted, what's new with you? How are things going? Pop something in the comments. See, we've got a few people watching. Say hello. Let me know what's new. Okay, well, that pregnant pause of silence is probably enough. I guess we don't have much to say, and that's fine with me. So I will say thanks for watching, and appreciate you being here with me today. I'll be back again next Thursday with another issue of Things Are Going Great. Thanks for asking. Both of you, you guys coordinated your answers there or something. In any event, thanks for being here. I'll see you again next week at 4 p.m. on Thursday. Have a great week. Take care.